The people of Central Kofi Akpafulikpe and Lulubi Sal have welcomed the Court of Appeal's ruling against John Peter Amewu yesterday. The Court of Appeal, presided over by Justice Bright Mensah, sitting in Koforidua, granted an interlocutory injunction brought by Professor Margaret Kweku and others from the South Traditional Area to restrain former Member of Parliament for Hohoi, John Peter Amewu. The court restrained Mr. Amewu from holding himself out as a former MP for Hohoi constituency in the 8th Parliament of the 4th Republic. The court also restrained the Speaker of Parliament from processing or paying any entitlement to Mr. Amewu as the former MP, pending the hearing and determination of the appeal. You recall that the whole High Court, presided over by Justice Owahine Champon, on July 29, 2024, dismissed the election petition against Mr. Amewu on the basis that the High Court lacked jurisdiction. Now, a notice of appeal was filed on July 31, 2024 against the High Court's decision, while an application for interlocutory injunction was also led on December 23, 2024 at the Court of Appeal. Arguing the application, lawyer for the applicant Tsatsu urged the court, in the interest of justice, to prevent the Speaker of Parliament from processing or paying any entitlements to Mr. Amewu pending the hearing and determination of the appeal. Counsel for Mr. Amewu also argued that his client had done no wrong, but instead, if there's anything, it's the Electoral Commission who should be held responsible for misleading Mr. Amewu, the second respondent. Now, the three-member panel led by Justice Bright Mensah, with Justice Noble Nkrumah and Justice Hafisa Ta Amaleboba, held that the application was meritorious, so they gave that ruling. The people of South feel they are happy about this ruling and they are excited. But what really does this ruling mean in plainman language? Let's speak to a private legal practitioner, Daniel Kupwalo, who's joined us on the line. Counsel, good evening to you. Thank you for your time on 505.
Good evening, my sister. Dorian.
Hello?
Hello, I can hear you.
Okay, so this ruling, what really does it mean? Somebody has been MP for 4 years, and now the court is saying he shouldn't hold himself as out as MP. This is done. What does it mean?
Well, basically, what it really means is that, you see, in situations where they are successful on appeal, lawyers for the petitioners don't want to find themselves in a situation where there'll be nothing to enforce in terms of if Peter Amewu takes his benefits and all that is entitled to, and they are successful, it means that there'll be nothing left. So basically, the victory in court would be rendered useless. So I'm sure this is an interlocutory injunction. That is, if they are also not successful on appeal, Peter Amewu can still assess his entitlements and benefits. So this is just an interlocutory ruling, meaning that pending the final determination of the suit, whichever way the suit goes, the final determination will not be rendered nugatory.
Okay, so this is pending the final determination of the case, and that he
true.
Shouldn't hold himself as a former member of parliament. The timing, one will say this matter should have been even determined before the member of parliament left office. Now he's left office. He's received salary as a member of parliament. He shouldn't hold himself as a former member of parliament. Yes, his entitlement, they are going to tell the speaker to hold on until the final determination of the case. The timing, does it affect anything?
Yeah, that's what I'm saying, that this is just, it will not affect anything per se, because if Peter Amewu is also successful on appeal, then remember that that order of injunction will be lifted. So it means that he can hold himself out as an MP. So we should be able that this is just interlocutory. This is just in between. Let's say while the determination of the appeal is going on. So whichever way you look at it, you get a short moment or a brief moment pending the determination of the matter. Because if the Amewu goes for entitlement and all that now, and as I stated, then the petitioners are successful, and it means that obviously there'll be nothing to hold on to after the court determines in their favor.
Then, I mean, one would say that the excitement in the people of Sal is just short-lived because you don't know what the final determination of the case really is.
That is so. That is so. That is so. But the injunction, sometimes the injunction can give an indication of where the case will go. Because once the court finds some merit in your application to restrain Peter Amewu, it gives an indication, but obviously that's not the final. So let's all keep our fingers crossed to the final determination. Mm-hmm.
This is interesting, but again, there's the same matter that had to do with Asenos that was determined earlier, before, I mean, the by-election, and then the people in Asenos had the representation. So it wasn't determined. 4 years passed, and now there's one leg of the case that has been determined. Just supposing those two cases, how are they different? You are a lawyer, so help us understand how almost the same case, there's some difference in arriving at the conclusion of a matter. One has been arrived earlier than the other.
Now there's the administrative side of justice. That is where an appeal is filed. There's a process that it goes through. That is compilation of the records, dispatch of records, etc., etc. And even the date. The court also has a hand in the determination in terms of the date. So in the case of Asenos, one could say that maybe there was the process was fast tracked in terms of administrative wise. Because remember that as far as the lawyers are concerned, there is a part also that the court plays in terms of giving of the day and the hearing of the appeal and all that. If you this particular story was heard in Kuporia, not in Accra. So that should also be the indication that the Kuporia Court of Appeal has its own time in different form. What is in Accra in terms of the date that is given. So in terms of the Asenos one could say that because the situation was the case was trapped, and then in the Peter Amewu one, we could also talk about delays, which could be administrative or which could also be the part of the lawyers in terms of how they were able to expedite the appeal process. So for the timing of the appeal, it's purely administrative, and then sometimes it depends on the lawyer, depending on how they cooperate with the registrar, etc., etc.
Again, the lawyer for Mr. Amewu argued in court that his client had not done anything wrong, but if there is anyone to be blamed for the situation, it's the Electoral Commission that should be held responsible for misleading, quote and unquote, Mr. Amewu, the second respondent, because they said, okay, the people didn't vote, so why punish somebody who applied to be in the process and not the Electoral Commission?
Yeah, but he was also a beneficiary of the decision of it. So yes, although he said that he should be punished, etc., etc., he was a direct beneficiary of the decision of the Electoral Commission. So if he's saying that he's innocent or he doesn't know anything about it, no, that cannot be correct. Because he benefited direct from that. And if he was just like a referee who is not able to determine a match very well, or is not able to go by the rules. Now the footballer or the team that benefits actions will be affected by whatever decision will be taken subsequent to the referee actions. I don't know whether I'm clear here.
Yes, I can get your point. So it looks like we have to keep our fingers crossed for interesting days or times ahead in court on this particular case, right?
That is so.
Counsel, very grateful for your time this evening. Daniel Kupwalo is a private legal practitioner. So, whilst we are talking about matters related to court,